That's been the big part of their argument today. Nobody wants it. All of Father's concerns, he raised several, from a machete knife to a cousin who has played with this child for its entire life. Absolutely none of those concerns, you just heard him testify, actually occurred, and then he stopped visitation. None of them were sufficient for him to say, okay, I'm not going to let you care for my child anymore. He continued to allow the grandmother to care for this child. He just started pulling back when he started to develop a relationship with a woman that wanted to be this child's mother. Now, you heard my client say, she's happy for this woman. She's glad that her grandson has this woman in her life. But that doesn't mean that my client doesn't exist and her rights don't exist. And there's a grandparent visitation statute for a reason. And Judge, just with respect to Father's credibility regarding when this mother saw the child, number one, we're easily able to show that the 10 times he said she saw him 10 days, period, no questions asked, between January and May. And it was only because the child was out of school. The child was in a daycare, but the child had to be out of daycare, so that's when she saw him. Well, we submitted irrefutable proof in photographs that she saw the child on I believe she said 27 occasions in which there were photographs. This is also, to take the father at his word, you'd be asking the court to accept someone that says they are on regular prescription medication, a Schedule II narcotic, and they take it 5 days a week, and then they just go off of it in order to drink. He stops taking his prescribed medication to be able to drink alcohol. Judge, I think that we've made and I hope that the court views it my way, of course, but I think that we've made a great case under 36-6306 to show that this child had resided in the home for 12 months or more, which creates a rebuttable presumption that denial will result in irreparable harm. Subsequently, that there's a significant existing relationship for 12 months or more, and as a result, that a grandparent visitation action should be considered. And then that a significant existing relationship was established because the child resided with the grandparent for at least 6 months, and another section that the grandparent had frequent visitation for not less than 1 year. Judge, this is all, as Your Honor knows, and as I've already cited, a reasonable person standard. And then, Judge, you flip over to the best interest factors, and I cited 1, 2, 4, 5, 8, 9, and 10. And Judge, I would implore the court that those all are in our favor. Thank you for the court's time.
In response, I guess, to narcotics and drugs, and my client wouldn't allow him to fully answer, but I mean, he's on ADHD medicine that he takes sometimes, and sometimes he doesn't. So, I mean, it's not like something he's prescribed to take every day or ordered to take every day. So, if he feels like he takes it one day, he won't have a beer while he watches the game. So I would suggest that that's a red herring. I would further suggest, co-counsel's talking about no one likes court orders, and we're talking about divorces and parenting plans, and we're talking about, I would suggest, apples and giraffes. And we're talking about two constitutional protected rights of parents versus a grandparent. They're just not the same. And I would suggest that, we're talking about a grandparent. We're not talking about a mother. We're not talking about a parent. I mean, we're talking about impeding on a father's constitutional right to determine, hey, this is what I think is best for my child and what's not. I would suggest to the court, of course no one wants to be under a court order, but again, we also can't live, I would suggest, defensively. Well, grandmother wants to buy diapers and wants to see the child and wants to help. Well, man, should I do that or not, Judge? Should I let my mother-in-law keep my 13-month-old son? Well, what if she decides she wants to see my child later on and goes and gets a lawyer? Maybe I shouldn't do that. So I would suggest to the court the purpose of the statute and the intent of the statute is not just to say, okay, well, because the grandmother extended courtesy, now she's got rights to this child until he reaches majority. I don't think that's the intention of the statute. Before I come back to the statute, and I probably won't argue it in depth as Mr. Whitaker and I rely on the court's background, but even her own witnesses, Desiree Yates, and ask and her opinion of Mrs. Hen. She's a typical grandmother, Judge, typical. And keep the child 3 or 4 days a week, and she might keep the child overnight. Same testimony from great-grandmother. I would suggest that suggests we have a grandchild-grandparent relationship. Jennifer Knight came and testified, and he said a couple of times a week she watched the child. She would come over for holidays when they lived in the house with the pool, and sometimes the child would be there. I would suggest to the court that's another witness that's telling us under oath we have a grandparent relationship here. The son who lived there, who came, told us very eloquently, yes, the child was dropped off every morning and then was picked up in the afternoon. My mother was the babysitter. Now, we enjoyed little Lawrence being there, the child being there, and we played, but that's to me what family does. So he also went and said, that's what my mother does. She's a retiree. She's a babysitter. That's what she likes to do. His words, occasionally I wrote down, overnight she would keep the child for hockey and football games. But even her own son that lives there, to me, if there was more of this relationship that co-counsel suggests, even he would be a more definitive witness as opposed to, yeah, she kept the child during the week. Miss Kidd, her witness, again, both voiced concerns with Miss Hen and her household, but again said, look, she's not a caretaker, she's a babysitter. You heard my client testify, and I sympathize with him to some extent. He's had to hire a lawyer. He's had to come in here, and he's being asked, well, do you like her? Do you want her to visit with the child? I'm not sure I would know either, Judge, if I had to hire a lawyer and go fight her in court over something. I think that's a reasonable, objectable person response to that. In talking about the best interest, and I'll work my way backwards, there are concerns in our household. To me, it was very flippantly kind of brushed off a suicide attempt. What, did you go talk to anybody after being in the mental institution? No, why would I do that, Mr. McFarland? Well, because you either drunkenly, impulsively allowed somebody else to almost get you to take your own life. You don't think that's worth going to see and talk to somebody? Nope, sure don't. Not an issue. They told me I didn't have to. If they told me I didn't have to, why would I take the reins by myself and just err on the side of caution and go talk to somebody? To me, that is not something that can be just shrugged off. I do think there's concerns, and the concerns by the father are legitimate with the daughter coming around. Again, I would suggest to the court, to me, there was something going on. We came to court, we couldn't find her, we don't know where she is. Judge, give us our visitation, and all of a sudden she appears. Now she's not here today. So I would suggest, what really would be in the child's best interest is we need to see where mom is, and mom needs to get better, and really, grandma's focus probably should some be on her daughter or trying to help her daughter. And let me be clear. Ms. Hen seems like she's a nice, good Christian lady. To adopt a child, right out of the womb, that's a wonderful thing. No one's suggesting it's not. We're not suggesting she wasn't a good grandmother. We weren't suggesting it was not appreciated what she did. What we're suggesting is that there's not the level of harm here that's being suggested. I'm unsure, Judge, what proof the court would find to be substantial harm. Now, I could be wrong every day. But, I did not see the harm or the proof of the harm here. There was certainly proof that she loves the child and wants to see the child more. But, 36-630-06, number 5, as suggested by Mr. Whitaker, talking about 12 months or subsequently in the house and not being consecutive, it also goes on to say that there must be a denial of visitation that must result in the harm. I'm not sure we have definitive, clear, convincing proof here that the visitation was denied. She just didn't like what they were offering. I didn't want him to come see him here. I didn't want to come. I wanted to be overnight. I wanted him to come to my house. The case law is very clear that reasoning or for grandparent visitation is, well, I'm getting visitation, but I don't like it. The Loveless Copley case is very clear. Look, if you're getting visitation or getting something just because you don't like what you're getting, that's not grounds for a grandparent's visitation. I would suggest that's what the proof showed here today, Judge. She was gone. Again, condolences, very sad reason to go to Florida, but she was still gone 5 or 6 months. I don't know how you could say the child's going to be in harm's way, and I was the primary caretaker, but then she takes off for Florida, and I heard 2 times in her testimony, Judge, 5 and 6 months at a time, but then when she comes back, I want to see the child when I want to, how I want to. Again, it's not saying she's not a good grandmother. I'm sure she does want to see the child, but I don't think you can have it both ways, Judge. I don't think you can say, well, I want to be daily caretaker now I'm going to leave for 5 or 6 months. To me, it just suggests that she's a family member and she's a grandparent. I didn't see anything in any of those pictures when I reviewed them before, when I reviewed them today, that didn't suggest, hey, she's a grandmother. And probably a pretty darn good one, Judge. We don't dispute that. But again, that's not what the statute says. It doesn't say, all good people apply, and if you're a good person, you can have grandparent visitation, or aunt visitation, or uncle visitation. Are you a good person? Were you good to your family when you had the opportunity to help them? That's not the standard, Judge. And I would suggest in the event it was, your court would be flooded. I said in my opening, sincerely, this situation is not too far off from my personal situation. I think mother-in-laws keep children all the time, and I would suggest that that's something they like to do, that's something they want to do, but that doesn't necessarily create a legal right, to bring a lawsuit and say, okay, I now have legal standing to get court-ordered visitation. I would suggest that that's not what we have here, Judge, and I don't think the proof showed that respectively. The statute says, again, in B1, function as a primary caregiver. She talks about watching the child roll over, watching the child take his first step. I would submit that's subjective. But I'd further submit, unfortunately, this is the world we live in when you have parents that work. My wife and I both work. What's that mean? Well, I missed his first crawl and I missed his first step. Does that mean my mother-in-law now has the right to take me back to court to get court-ordered visitation if I don't let her babysit my child anymore? I'm not happy that I missed it, but I've got to work, Judge. I'd hope that my mother-in-law, when my child's old enough, takes my child to interact with other children in Mother's Day out. To me, that's part of the right and privilege of being family. And it's not something you do and then say, oh, by the way, since I did that, here's what I need. I would just, again, go back, I don't think she was ever a primary caretaker. I don't think she was ever a full-time caretaker. They tried to kind of somewhat skirt around it. Well, she was kind of like this, and she was never, ever the primary caretaker of this child, Judge. Anytime the child resided there, the father was there. And again, to her credit, being a good grandmother, I believe she is, she told the truth. He's a good father. He spent time with the child before he went and played his games. Again, those are things good parents do. That's good things that good grandparents recognize, and it's nice that she does. B3 talks about, I would submit again, that there's no clear today that the child's not doing good, that the child is going to suffer any substantial harm. I would further suggest that the proof here would certainly come into question the best interest. A lot of people coming and going from her house through no fault of hers. It might be good Samaritan reason, but it doesn't change the facts that there are. She's a mother of a daughter that we don't wish on anyone that clearly has a sickness. Again, I take no pleasure in saying that's a reason she shouldn't have a court order to see her grandson, but the facts are, by her own admission, the daughter had heroin needles in the house, and she's come back to live there a couple different times. That's just not something that's suitable for every other weekend visitation for a young child. So I'd submit that it's not in the best interest. In addition to, the court did find substantial harm, we would ask that if the court did find harm, that there would not, it not be in the child's best interest to visit that often, or there'd be a court. Again, Judge, nobody likes to ask for attorney's fees. Again, my client, but for her filing the petition, so he is requesting attorney's fees. We would ask in the event the court did see it our way that, upon drafting the order, we leave it blank and submit an affidavit. As previously suggested, it is not about the money. It is not, he's not fighting this or not giving visitation because she had to hire a lawyer, but the fact of it is lawyers are like TVs and computers and cars. They're not free or cheap, Your Honor. So based on the proof submitted, we ask that the court deny the request and grant attorney's fees.
Brief last word.
Brief rebuttal, Judge. Because of course there's a grandparent-grandchild relationship here. They keep saying this is just a grandparent-grandchild relationship. That's all that's what the statute was formed around. It's referred to in the code as a grandparent visitation rights. We're not trying to say she's anything other than a grandparent. And Judge, I would submit to you that Mr. McFarland attempted to make comparisons to himself. Well, this statute's not even applicable to him. The child's father and mother are divorced, legally separated, or were never married to each other. This statute has nothing to do with his life. He's married. So that they couldn't come in here and file. That's not, it's just not. Judge, he allowed the child to return after concerns. He raises all these concerns, the suicide attempt. It's irrefuted that, well, you can still continue to watch my child. I really, I think it's in my child's best interest, obviously, for you to continue to do that. And it's not true that she didn't just not like what she was getting. You heard testimony that she said, "Can I just FaceTime?" In fact, it's one of the exhibits. "Can I please just FaceTime? Can I please just FaceTime? Can I please just go on a dinner date? Can I come to your house and watch him while you go to the grocery store?" She was willing to do anything and everything to accommodate it. This is not a situation of she didn't like what she was getting, Judge. And I think that Judge, one more thing that I want to point out is under subsection 6, then it goes down to subsection 3 of 6. It talks about, it says, a grandparent is not required to present the testimony or affidavit of an expert witness in order to establish a significant existing relationship with a grandchild, or that the loss or severe reduction of the relationship is likely to occasion severe emotional harm to the child. Instead, the court shall consider whether the facts of a particular case would lead a reasonable person to believe that there is a significant existing relationship between the grandparent and grandchild, or that the loss or severe reduction of the relationship is likely to occasion severe emotional harm. So, Judge, under that standard, I would submit that we have met our burden and ask that the court award my client visitation in accordance with her testimony.
Okay, well, it seems like for a while, these folks got along rather well, maybe even get along reasonably well as we stand here today. The difficulty or ire, confrontational nature of litigation often has a way of eroding what is often little trust or cooperation that exists prior to the litigation's commencement. From my view of the facts of the case, the issues really started in early 2019. Despite arguing over what we call it and how we characterize it, it seemed that prior to then, the petitioner saw the child frequently on a regular basis, whether you call it a caretaker, babysitter, not for Titans games, yes for Titans games, however you want to sparse it and argue it, it seemed pretty clear that she was acting in a role of, in my view, a babysitter, but you could call it a caretaker. But bottom line is she saw the child often, didn't charge for that service to the father. It's a service the father needed, and things are going reasonably well. From the proof then in early 2019, petitioner advised the father, my parents aren't doing well. I'm not going to be able to continue to watch your child. You probably need to make some other arrangements. And so, henceforth, he did make those arrangements. Those kind of fell off, and in between, the grandmother was in Florida and back again. Then in about May, after the child had been out of daycare and the grandmother had watched the child for about 10 days, the child got into a daycare in the summer then of 2019. The father said, I'm not so sure about the overnights, continue to have the day visits. Grandmother wasn't really happy about that, but that continued. Often saw him at parks or restaurants for visiting for dinner and that sort of thing. Then, in the fall of 2019, grandmother said, got to go to Florida for good. Maybe June, I think, was the testimony. No, there was a trip in June, and then there was another trip in September for good. So she did leave in the summer of 19 for several weeks, come back, and in September went to Florida for good. And so the normal course of the visitation that had occurred during that summer stopped altogether, and there were some accommodations made by the father for the grandmother to have some FaceTime or video visits and so on and so forth through that fall period, which the grandmother said wasn't as many as maybe she should have done. I didn't really hear any numbers in the proof, but clearly there were no in-person visits occurring between the grandmother and the child during this period. Grandmother notified the father that she would be in late on Christmas Day, the 25th in 2019, and wanted a visit, wanted to come straight from the airport that night or first thing in the morning. Father advised, we've got a pre-planned trip. We're leaving at 6 a.m. in the morning. Grandmother insisted that she would come by at 6 o'clock before they left. Father declined that. Then grandmother said, I'll show up on your vacation in Jacksonville and get my time then. Father also declined that request. And then subsequent there too, the grandmother was off to Florida again, where she stayed until February the 29th. Had asked a few days before coming back about immediate access to the child. She testified that after 5 days of requesting and being denied over multiple occasions of times and places that she suggested she should be able to see the child, she went and hired a lawyer. Brief shows that a lawsuit was filed in this matter on March the 18th. So 17, 18 days after return to Tennessee, grandmother had filed this lawsuit, and frankly, surprisingly to me, seemed surprised herself that thereafter she's not received any cooperation with the father to set any further visitation. I'm not sure what the expectations were, but oftentimes when someone gets served with a summons, a lawsuit, it doesn't bring about an air of cooperation, and it just doesn't seem surprising to me, but the proof seemed to be that grandmother held that against the father, even though she had sued him for the visitation. So, those seem to be the relevant time periods and the facts in making a decision in this case. There was a lot of slings and arrows about things that happened years and years ago, and who did what, and played video games, and whose grandchildren had swords or whatever. All that. There was continued relationships all throughout that. I mean, I understand you're in a lawsuit, and you kind of have to start talk about something, but that's the time period that seems to me to be the most relevant. When looking at 36.6.306, clearly number 2, parties are never married, so the standing part of 306, which involves these different factors, the petitioner argued 3. Clearly that's one that's applicable. The number 5 was argued by the petitioner as applicable, and I think I need to address that as a period of 12 months or more subsequent to being removed from the home. The child resided in the home of the grandparents. I found one clear 7-month period. It's true the father was there. The statute doesn't talk about solely living with the grandparent, so the child was in the home for 7 months. The subsequent time when the mother moved back in and had 50-50 time, and the allegation is that the child was living with her during that 6-month span or 5-month span. When it says live there, it means resided. I don't know that you could call shared parenting time that is being exercised primarily in the grandmother's house as a residence. I don't think the 12-month period would have been met under 5. And under number 6, certainly it wasn't 12 months immediately preceding the severance or severe reduction of the relationship. And the other significant language in the statute is that this relationship was severed or severely reduced by the parents, or custodian. And really, although mentioned in number 6, I think that language is relevant to the court's next determination, which is a finding of danger of substantial harm to the child. In this case, you have a unique circumstance where, frankly, the severance and severe reduction of the visitation was precipitated by actions taken by the grandmother. And then she comes into the court and complains that a severe reduction in the time that she's allowed to spend with her grandchild would result in a danger of substantial harm to the child. Now, that's not to say she didn't have a good reason for leaving and moving to Florida for 6 months. It's not to say that that's not what she should have done. It's not to say that that's what anyone wouldn't have done in her role, because she was not the child's parent. It was not her job to take care of the child on a daily basis. And she understood she had a higher calling to her parents. So I'm not suggesting that she did anything wrong, but you're not able to come to court and argue that this severe of a reduction in the relationship that existed when she left the state and moved to another state it was argued to me that just because that's something she had to do, it didn't really happen. It happened in a vacuum, and it didn't have any impact on the child or the father or their relationship or how that went. The statute presumes that this severance of a relationship was precipitated by the parent against the grandparent. But here, the severest reduction of all was by action of the grandparent. And if that severe reduction or stoppage of in-person visit would have occasioned a substantial risk of harm to the child, then I assume that either the grandmother would not have went, or she really doesn't believe it would have substantially harmed this child. She clearly loves the child. Look, it's not a choice that anyone would want to make, but the argument here is untenable in the court's view for it to find that there's some danger of substantial harm to this child. Because I have to either find the grandmother intentionally subjected the child to it, or it didn't exist in the first place. Either of which is not going to give rise to prevailing under the statute as I see it. Parents have a constitutional right to parent their own children and make decisions with regard to what's in their best interest. These statutes carve out very limited and specific exceptions to that constitutional right for parents. And if the court cannot make findings on this multi-level, multi-layered statute that sets out first this, then this, then this, and then if you do all that, then you have to go to another statute to talk about best interest. Here the court is not going to reach any best interest analysis because the court's finding today is that the petitioner has failed to meet her burden under 366306, specifically failing to find that there's any danger or substantial harm to the child. Furthermore, I find that in light of the facts of the case, I'm not sure there was really even time for a denial of visitation by the father to the grandmother. What we have is the grandmother demanding, at convenience to her schedule, specific times and specific dates that work for her that the father said don't work for me. And literally by her testimony, as I stated in the finding of facts, within 5 days of being dissatisfied with the father's responses, she was ready to file a lawsuit. I understand she was nervous and scared and anxious, but I really didn't hear about all these issues while she was in Florida, gone, away from the child, only upon her return and ready to resume her, reinsert herself where she was 6 months ago, 5 months ago, and not being satisfied with that response, did she become so upset about not being able to demand access to this child. And it just doesn't meet the statute. It's not the intent of the statute for this set of facts in this particular case. The severance here is by the grandparent, not by the father. And there is no finding of substantial harm to the child should the grandmother not be awarded, in her request, every other weekend and a dinner date during the week, which would be akin in and of itself to a parental type visitation for a non-custodial parent. So with those findings of fact and analysis of the statute, it's the decision of the court that the petitioner has not met their burden and the petition should be dismissed. The cost of this matter would be assessed to the petitioner and the respondent is awarded attorney's fees. Mr. McFarland, you'll draw the order, leave a blank for your fees and submit an affidavit and send that over to Mr. Whitaker for his review. We'll set 5 days and I'll review the affidavit, fill in your fees on that order. That is the ruling of the court. I wish you both well. I hope you work it out in an amicable matter as you move forward.